Arbor Manor versus Jimmy Cajon. You know,
Well, I'm surprised.
Yeah.
Thing for the plaintiff.
Surprised she's not here.
But I did learn some things, Your Honor.
Pardon?
I did learn some things about this case after last week.
Okay. Did we get, can you see if there's another escrow payment?
Yes, I do.
Got it. All right. Yes, sir. What do we want to?
So the work had been done, and she showed us a photo last week of her tub covered. They've been over since. There was some painting that needed to be finished last week. I guess actually this week, since we were here on Friday. And the glazer had left a note that she could remove the covering on the tub by a certain point, but apparently she either didn't see it or didn't understand that was for her. But the work has been done. Her window was broken. Her front door window, storm door, was broken either Tuesday or Wednesday. My client sent me a picture on Wednesday of it. It hasn't been reported, but as far as I know, there are no open work orders there. And so I'd like a judgment with the court's consent and a release of the escrow to the plaintiff.
Right off the bat, you can feel the tension. Plaintiff's not even present, yet the attorney is presenting updates about repairs, windows, and escrow. It's a classic civil case scene. Small details like a broken tub cover or storm door can have real legal consequences. Notice how the lawyer is asking the court to release escrow. That's money held until obligations are met. Viewers, here's a thought. In landlord-tenant cases, how much do you think property condition impacts the judge's decision?
All right. And you, did we swear you in? No. Solemnly swear affirm testimony you're about to give will be truth, whole truth, nothing but the truth. So you got.
I do.
All right, go ahead.
Yes, Your Honor, in my previous case today, I don't think you had a chance to get a word in. So, Your Honor, this is an action for non-payment of rent. This defendant owes $3,285 in rent. The costs are $175. The total redemption amount is $3,400.60. I'll repeat, but more briefly, what I'd already put on the record, which is that, to my knowledge, and after consulting with my client both today and Wednesday, there are no open work orders. There's a broken window in her storm door that has not yet been reported, but it could be that it'll happen next week before we get to the New Year's Day holiday. And so we request this judgment as possession only with a writ to issue after the statutory period. And may I add to the judgment that escrow is to be released to plaintiff. And could I have that amount, Your Honor?
Yes, it's 2,100.
2,100. Thank you.
Judgment to the plaintiff, that's by default for possession, reduction amount, any amount requested.
Now we're into the financial nitty-gritty. $3,285 in back rent, plus costs totaling $3,400. This is a possession-only judgment, which basically means the tenant could be evicted even if they eventually pay up. The attorney emphasizes no open work orders. This shows they're trying to make the case bulletproof. Audience question. If you were the judge, would you allow some leniency for minor repair delays, or stick strictly to the rules?
The writ issued in 10 days, escrow may be released to plaintiff. He's gonna bring me court does call the case of the Evergreen Apartments versus Thomas Fleming. And is it LT Johnson? I'll take that. That goes in there. Your name, sir?
Thomas Fleming.
Yeah, and you got that lines on there that.
Yeah, they blew it.
Just, what was that yesterday? Is that your fault?
It's not my fault.
Oh, okay, all right, just checking. All right.
We're wearing it because it's a pullover. It doesn't have a zipper, so it's warmer.
Warmer, gotcha. Okay. Warmer than team was. Anyway. Wow, you sound better.
So
Where are we on this case?
they couldn't get Terminix over the holidays. They scheduled it for the 2nd
Actually, they're going to be there today
today.
and
They didn't tell me that. We were not ready for today.
Who were you talking to?
I was talking to Brooke Austin, property manager. And she told me they weren't coming till the 2nd.
Right, but when was that conversation you were having with her?
I had it maybe a couple days after.
The last time we were here?
Yeah.
We were here on the 19th.
we're here on the 19th, on the 20.
Here's where the human element comes in. Miscommunication about treatment dates and access to the apartment causes chaos. This highlights how procedural delays and miscommunication can complicate even straightforward cases. The court is balancing fairness with practicality. Can the tenant prepare their home properly? That's a scenario you don't often see discussed in legal commentary, but it's huge.
4th, I have a note that says this week's treatment is delayed to 12/26 due to the holidays. Next week's treatment is also delayed to Friday 1/2 due to the holidays. But it's, Your Honor, it's the same issue, which is they can't even properly assess whether the treatments are successful because of the condition.
Right. No, I get that part, I guess.
But everything,
I mean, my
we
concern.
took everything
Hold
down.
on.
Sorry.
That's all right. My concern is last time we were here, it was very clear to the court that it was going to take place that week on the 24th or 23rd or 24th. That didn't happen. It's now going to take place on the 26th. He's indicating that that's not the communication. He had the second date, but didn't have the 26th. And it's a weekly treatment, right? So do we know from the 2nd when the next one after that would be?
They're on Wednesdays,
They're on Wednesday, so it would go to the 7th. Okay.
So 2nd is Friday, and then it would be the 7th.
7th. And you guys aren't ready for
Well, we celebrated and we cooked. So there's some dirty dishes that I was going to clean today. And there's some stuff I need to move around in the mom's room so they can have access. It's kind of difficult because she's got her medical equipment in there, her bed, her walker, and some other things.
And you were assisting with that, right, sir?
Yes, Scott. Yes, yes, I'm assisting Kevin as best I can. He has a nephew who doesn't want people in the home, so I don't have a lot of access, but he is, because of his mom's in there, it's just so hard for him to prepare. He tries to get her out of the home when they're doing the treatment.
That's the other thing.
He needs proper prep time, and somehow there seems to be a communication mishap where they're not, either they told him he's not getting the message, but they're not informing him when they're there so he can prepare, so.
And here's what
I booked a hotel for the 2nd for my mom. I booked a hotel for my mom for the 2nd to get her out. But I need assistance in getting her up the stairs.
No, I got you. I understand that prop. So when you booked the hotel for the 2nd, did you do that also for the 7th? So thing is, I'm not sure what to do with today's date, but you're going to have the treatment on the 2nd, right? But then that following week, they're going to go back to that Wednesday.
Yeah.
So the hotel that you booked, I don't know.
It's only to the 3rd.
Okay, but
So I'd have to book another hotel. room.
I got you. I just want you to be aware that you're gonna need it for the 7th.
Yes.
Okay.
The judge steps in to reset expectations, a settlement conference on January 6th. Notice the strategic move here. Judges often schedule these conferences to get both sides talking and avoid repeated delays. It's a reminder that the courtroom isn't just about punishment, it's about finding workable solutions. Think about it. Would this approach reduce future conflicts or just prolong tension?
Well, I don't know. We can go either way, but I don't know what to do about today. They're not ready. They're gonna not get there.
What about a settlement conference on the 6th?
Do I have that date?
The 6th is available, yes.
All right. Here's what I'm gonna do, sir. Set a final settlement conference for January 6, 2026 at 9 a.m. That'll be an in-person hearing. All right. And then I'll be able to sit down a little bit more in detail with the parties and figure out structurally what we're gonna do and try to resolve this. Okay, fair enough?
Mhm.
Okay. So we'll do that day. When you come in on that day, I won't be in my courtroom. I'll be down in courtroom A, the first courtroom when you come in.
Okay.
Okay?
All right.
Thank you.
Thank you.
Have a
Thank
good
you, Your Honor.
New Year.
Happy New Year.
Evergreen Apartments versus Dustin Mickles and Antoinette Mickles. Got either one of them? No, we don't have either one. You may proceed, sir.
The judge laid out a strict payment plan and made it clear that one missed deadline would trigger eviction without delay.
So Your Honor, they had lock approval for 3,000 if they could get to 3,000.
Right.
They're going to be over 6 if we come back next week.
Now we get into strict payment deadlines and conditional judgments. The court is giving clear, enforceable instructions. Pay $1,000 today, another on the 9th, and the balance plus January rent by the 30th. Miss a deadline and eviction can be triggered immediately. This is a textbook example of how judges enforce accountability while giving structured opportunities to comply. Audience engagement. Would you describe this as fair, or is it adding too much pressure? Drop your thoughts.
And they're not here. May I?
Yes, you may proceed.
Your Honor, this is an action for non-payment of rent. These defendants owe $4,570.91 in rent. The costs are $214 for a total redemption amount of $4,784.91. This is a possession-only judgment. We request a default with those amounts with a writ to issue if that's not paid on or before January 5th.
Judgment to the plaintiff, that's by default for possession. Redemption amount is in the amount requested with a writ issue.
Thank you.
We're okay. Court does call the case of Evergreen Apartments versus Kyla Jennings. Exactly.
James Fink for the plaintiff.
Your name?
Markayla?
And where are we on this?
She's at 2488.
Did you pay the 1,000?
I just didn't get paid yet. I get paid every 2 weeks, Fridays, but I haven't got paid today yet because of Christmas,
Oh, so you haven't, it's today you get paid, but you just haven't.
but it hasn't came yet.
Then how are you gonna get the rest of that paid up?
I just pay as much as I can every 2 weeks, every time I get paid to bring myself down. And then just raises itself back up.
How much is your monthly rent? Hereabouts.
1194 plus the utilities and trash. She'll be at 3756 next week.
in unit 2, going to be about 1756 short. So, ma'am, let me ask you this. You're gonna pay how much today? 1,000?
Mhm.
Then you get paid on the 9th, and how much you gonna,
It'll probably be more than 1,000 on the ninth,
more than by how much?
maybe like 1,100, not too much more.
Okay, but a little bit more, okay. But if I just take that as 2,000, then you're gonna be 1756 that you still owe. You follow me? Cause if
I think I can have it all paid before January 31st.
what's that mean? You know,
The full balance before
now
January.
I know what it all paid means. What do you mean by what date are you talking?
Right before the first kicks in.
All right.
Whatever is the
Here's-
last month, whatever is the last pay
yeah.
period.
Here's what I'm gonna do. All right. I'm gonna grant a judgment, finding no tribal issue up here. I'm gonna grant a judgment for possession to the plaintiff. Okay. For what is today, is it 2988.52? So I'm gonna grant them that judgment. Defendant to pay $1,000 on the 26th today. Defendant to pay, I'll just make it an even 1,000 on the 9th of January. Got that?
Mhm.
Okay. If that's paid,
She asked for more time, but the court gave conditions instead, turning hope into pressure with exact dates and
defendant to pay balance plus January rent by January 30th.
What day, Your Honor?
January 30th,
Thank you.
2026. If any of those payments are missed, then a writ may issue after the 5th. Okay?
Mhm.
Of January. So you follow what I just did?
Yeah.
I'm trying to give you a way to get yourself out of this, okay? So you gotta pay that 1,000 today. If you don't pay that 1,000 today, then they can seek an order of eviction on January 5th,
Okay, but not until the 5th.
but not until the 5th. If you pay the 1,000 today, I'm basically giving you to the 9th, where you're gonna have to pay the other 1,000.
Okay.
Got it? Don't pay that, they can get a writ. They
Okay.
can get the writ. If you pay that on the 9th, then I'm gonna I'm gonna give you to the end of the month to get everything caught up.
Okay.
Fair enough?
Mhm.
That work for you, you think?
It's okay. Yes.
It's okay? What do you mean it's okay? Will it work for you?
I think so. I hope.
Okay.
Thank
Well,
you.
me too. And I'm doing that based upon what you said. All right, so I'm gonna enter that judgment that way. All right?
Thank you.
You take care. Have a good day.
Thank you, Your Honor.